So this is a brand new topic, very interesting. New Hampshire is a trust focused state. We have a lot of money parked in trusts here. So I'll just set that up for you, Ian, and would you take it away?
Absolutely. Thank you, Chair Hammond. And thank you, members of the Commission, for inviting me to present on my law review article on the blockchain and asset protection trusts. And just for context, this is a law review article I wrote a handful of years ago. I co-authored it with attorney Brian Quirk on using the blockchain for asset protection planning. And I'm going to speak a bit about that. I'm going to give you kind of a high-level overview of why the blockchain can be very useful in this pre-existing, expensive often, and risky area of law. And then I'll talk a little bit about how New Hampshire can exploit some of these openings in terms of policymaking. So we'll go on to the next slide. Oh, and sorry, just to clarify, I'm here not as a lobbyist today, but just in my capacity as a volunteer board member of the New Hampshire Blockchain Council. So I expect all of you know what smart contracts are, but just in case, to give a little bit of introductory coverage, of course, the innovation of the blockchain is that it decentralizes a ledger containing a series of values across different nodes in order to ensure that nobody can tamper with the ledger's thereby rendered immutable. And for some, the real innovation of the blockchain was not just the capacity of making this series of values immutable, but what if we could make entire programs immutable? What if we could make whole self-executing systems immutable? And the programmers that first created these called them smart contracts, I think because they were thinking, well, the major area where we would need an immutable self-executing system is in the realm of something like a contract. We want to be able to look at the program on the blockchain and see, all right, if I'm going to purchase this digital file from you and I'm going to deposit the purchasing price into the smart contract, which is on the blockchain, the smart contract's going to, let's say, verify, for example, that I deposited the money, and it's going to verify the digital file and send it to me. And without any sort of trusted intermediary, I can look at the smart contract terms and I can see this is exactly how the program is going to execute once I hold up my end of the deal. And smart contracts, the name smart contract is a little bit misleading from an attorney's perspective. A smart contract could potentially, in some scenarios, be sufficient to constitute a legal contract, or it could be used as a part of the execution of a legal contract. There's some room for overlap between the two, but attorneys who aren't familiar with this technology in particular sometimes are confused by this term smart contract, because not all smart contracts are contracts, and in fact, conceptually, they're pretty different things that just happen to have some overlap some of the time. So what I think that people who coined this term smart contracts, though, didn't realize is that while there is a need to remove trust from the execution of contracts, and there's a need for maybe making sure that these systems are immutable, there is an area of law that's an expensive, internationally in-demand area of trusts litigation, where a lot of attorneys spend a lot of time and make a lot of money fighting specifically about the issue of immutability. This is an area of law across the world where the main aspect of a trust that is in demand and that comes up before courts is the immutability of the trust. And since a blockchain-based protocol is really the most immutable system in the world, there's tremendous potential for innovating in this area by taking this expensive and sometimes risky area of law and just moving it onto blockchain-based protocols. So we'll go on to the next slide. All right, so self-settled asset protection trust, or an APT, is now a pretty well-established, familiar financial instrument. And you've heard about asset protection trusts, even if you haven't heard this acronym. In particular, if you've heard about people putting their money in the Cook Islands or the Cayman Islands, you probably were hearing them talk about an asset protection trust. And the Cook Islands, I'm going to give you an example of a case where someone created an APT in the Cook Islands, and it was a state-of-the-art APT. But asset protection trusts did not originate as creatures of statute. They were not created by state legislators. They really originated because of the nature of civil contempt sanctions and because of the nature of due process protections in the United States. some smart attorneys took a look at these pre-existing concepts and realized that the possibility of an APT logically followed from some well-established legal principles. So rather than kind of give you an abstract definition, I'll just give you a concrete example of how this worked in a particular case. This is an example I used here in the Law Review article of a federal district court in Florida, and this was a very well-executed asset protection trust. And this settler of this trust got away with quite a bit more than some settlers would be able to get away with because this trust was so well put together. But this defendant in this is a 2014 federal case in Florida. In the midst of litigation, several months after he'd been sued, he decided he wanted to protect his money from a potential judgment. So while litigation was ongoing, he created a self-settled asset protection trust in the Cook Islands, and he transferred, I think, $1.7 million there. And the trust was structured to say, I want you to, I relinquish all control of this money. Under no circumstances are you to release this money to me, to anyone else. If I beg you to release all the money, you cannot release the money. If I'm ordered to release the money, you can't release the money. You are to do nothing but keep all the money in the APT and pay me $10,000 a month for my support. And this is one way you can structure an APT. There are some other popular mechanisms to structure them. One kind of hybrid model some people use is they create an APT where it's initially flexible and revocable. They have kind of free access to the money. But if your trustee in the Cook Islands or the Cayman Islands or something determines you're under a condition of duress, they will convert it into this irrevocable trust where you can no longer reach the money even if someone has a gun to your head, or even if you're in a litigation context where you might be compelled to surrender the money. So in this case, though, it was a very simple, straightforward, under all circumstances, keep the money, do not give me access, and pay me $10,000 a month. And so there was a judgment. There ended up being a civil judgment against this defendant, and the creditors, judgment creditors, sought to obtain this money from the trust. The trust was well structured, and they weren't able to obtain it. And so there was an attempt to hold this defendant in civil contempt, which is the biggest risk of a self-settled asset protection trust. Nothing like this happens to the vast majority of people that create APTs. They're well established. Most APTs are so well structured they don't even come under legal attack. But of the substantial minority that do come under legal attack, the biggest risk is you can be held in civil contempt and jailed, which obviously is a serious risk that clients, that defendants, potential contemners want to avoid. And so the court was trying to determine, should I hold this defendant in civil contempt and potentially jail him if he does not release the money from the APT, which is, of course, something that's impossible to do. And the defendant, the potential contemner, showed the judge, he introduced evidence, introduced the trust instruments, introduced testimony showing this trust is effectively immutable. They didn't use the term immutability, but that is what was being litigated. This is immutable. I don't control it. It's irrevocable. I cannot change the trustee. I cannot order the trustee to do anything contrary to the terms of the trust. And so the court held, under just regular civil contempt principles, not under a statute, civil contempt principles and due process principles, all right, these pre-existing well-established legal principles tell us that you cannot hold someone in civil contempt for doing something that it is impossible for them to do. Civil contempt sanctions are not a punishment. They are a mechanism for compelling compliance with a court's orders. These are the well-established principles of civil contempt, not created around APTs. That's just how civil contempt works. So the judge said, all right, well, I found that this would be impossible to order him to disgorge all the funds in this trust. Therefore, I cannot hold him in civil contempt because of what's just called a defense of impossibility. So this is why asset protection trusts work. It's because they create this condition of impossibility, i.e., they create immutability. And this is what was litigated in the case. This attorney was making his living demonstrating through testimony, explanations of the terms in the trust instruments, and other complicated factual questions, demonstrating immutability. This is how this area of law works. Now, 20-some states, including New Hampshire, in response to these sorts of developments, have enacted statutes giving some express protection to this concept of APTs to try to attract APT business to their states. And it's worth saying something about the Cook Islands. The Cook Islands, this is like a third of their GDP. There's 10,000 people in the Cook Islands. They're small Polynesian islands. They are a sovereign country, and they don't have a lot of natural resources. So they really just ask themselves, how can we use our status as a sovereign nation to generate income? And they essentially decided we're going to come up with these novel financial instruments that offer protections that many other jurisdictions don't have. And there's a kind of, I think, cryptocurrency related ethos there, but also just a granite state advantage sort of policy making lesson there from the Cook Islands. And this is kind of what New Hampshire and some other states tried to do with some of these statutes in our trust code. There I give a couple of the key citations in RSA 564B. But we have, even though these APTs are not created by statutes, we recognize them in New Hampshire in a couple of ways that can be helpful to settlers and attorneys. One way is that we expressly say in statute, you may create a trust here where the trust is exempt from both voluntary and involuntary transfers of your interest. So you can create an irrevocable, essentially immutable trust under New Hampshire law. And additionally, we say expressly in statute that then the money that you have surrendered control over, also creditors are going to be unable to access. This is in New Hampshire statutes. So this is helpful to people and potentially could attract people to the state in a couple of different ways. One is that you're kind of showing courts, no matter where you may be litigating, if your trust is based in New Hampshire, that the trust is exempt from these voluntary and involuntary transfers. It really is immutable, theoretically, under New Hampshire law. And also, we're saying expressly that it's protected from creditors, and so the judge can kind of see, all right, this is above board. New Hampshire recognized this in its state law. The concept of an APT predates any of these statutes, but the statutes help insulate it, give it some extra protection, and ideally the thinking is let's attract this business to states that innovate in this area of policymaking. Let's do the next slide. Now, that said, traditional APTs, even really well-constructed APTs, have a lot of challenges, and this is why there are attorneys who make their living litigating these kinds of cases. And you might get a sense of what some of those are from my description of the 2014 Florida case, although that was a successful APT. So here's some examples of some of the challenges you can face and why traditional APTs can still be risky and expensive. And as I go along, I think you're going to start to see how a blockchain-based asset protection trust could solve all of these problems. And then I'll try to tie a bow on this at the end and talk about how New Hampshire could address some of these issues in statute. So the problem is basically that we don't want to let people use the APT structure cynically. If you've done a pretend APT, everyone would agree, where you actually do control all the money in, let's say, your Cook Islands or your Cayman Islands trust, then we don't want to exempt you from civil contempt because civil contempt could compel you, theoretically, to turn over the money. And we don't want to protect those funds from creditors. The deal, basically, is that you protect the money from creditors by protecting it from yourself. And if you haven't done that, we want to subject you to civil contempt to get the money. The problem is that any protections you can think of to ensure that cynical bad faith APTs are not treated like APTs also can create a lot of expense and risk for people that have actually done sincere, good faith, lawful asset protection trusts. So the first obstacle is that the settler, the person who created the trust and put the money in it, this person has the burden of showing impossibility. It's rather always, anytime a defendant in any civil contempt proceeding is pleading impossibility, it is their burden to show the thing is impossible. That can be difficult to meet a burden. And so you have to, at your own expense, pay an attorney, produce the evidence to demonstrate that the thing can't be done, that you're potentially being ordered to do. Now, one particular problem that comes up in the case of self-settled APTs, and you see this in a lot of the case law, is that judges that are unfamiliar with this instrument can sometimes just be incredulous that an APT is real if they haven't heard of this before. They're skeptical that the APT really exists and really functions in the way you allege. So this is a quote from a 1999 case that appears in all kinds of APT cases. Many courts have quoted this statement and said, yeah, I agree with this, and used it in their opinions. While it is possible that a rational person would send millions of dollars overseas and retain absolutely no control over the assets, we share the district court's skepticism. This is from the Ninth Circuit. And many other courts, when they're going to find against settlers of APTs, they quote this quote to say, yeah, I also really doubt that you actually surrendered control over these millions of dollars. And what's notable here is they quote this not to say, well, you did surrender control over this money, and I think that's sketchy and morally illegitimate, and so I'm going to hold you in civil contempt. That's not what the courts are saying. That would be a violation of due process and standard canons of civil contempt and impossibility. What the courts are saying when they quote this quote is they're saying, I doubt immutability really exists here. I'm pretty sure, defendant, you actually somehow control this money. You could get it all if you wanted. So you can see how what's being litigated over and over again in these cases is immutability. One finding that sometimes trips up defendants is there may be accidental backdoors in the trust instruments themselves if the trust is not very well crafted. Something people run into sometimes with potentially Cayman Islands trusts is sometimes the trust instruments on their own terms will say you, the defendant, the settler, may appoint a new trustee. And so courts may say, aha, this is a backdoor. You, by the terms of the trust, you cannot order the trustee, perhaps on some theoretical level, to turn over all these funds to you, but you could keep appointing new trustees until you get a trustee that's going to comply with the court's orders, and therefore it's not immutable. There's an accidental backdoor, and so then these defendants get held in civil contempt and jailed until they can get a trustee appointed who will comply with the court's order. There's a big risk here, though. What if the court is just mistaken about the contract's terms? This is a real problem that defendants may have to worry about. These trusts can be complex. There can be a lot of clauses in there. What if the trust is sufficiently well structured that the defendant, is not able to appoint a new trustee and or use some other backdoor under the instrument's terms to get control of the assets, but it's not sufficiently well structured to show a judge that it's immutable? Then the defendant gets held in civil contempt, and the defendant can't even get the assets out to get out of civil contempt, and you can be held in civil contempt indefinitely. Again, this is a small risk. APTs are a great device. They work very well a lot of the times, but this very small risk is very big. Being indefinitely jailed is potentially a substantial risk defendants want to avoid. All right, next slide. All right, here's another big problem, and this is probably a bigger problem. This happens more often, is this finding of an unfalsifiable de facto backdoor. So what happens more often is in cases where defendants or contemnors lose and get held in civil contempt is sometimes the trust instruments are perfect. The attorney who drafted it did a great job. All the terms in the trust instrument show it's completely immutable. There's no way that the defendant can get control of the funds. But the judge finds, for whatever reason, and this isn't just you failed to meet your burden of proof, but the judge actually will conclude, I conclude based on testimony, or I just don't quite believe you, or some other reason, that notwithstanding what the trust documents say, those documents are a sham and you control the money some other way. So this is a case, this is another federal district court case and made it up to the Seventh Circuit in the 80s and this was a US-based trust, which people don't do this so much anymore, but this guy set up one of these self-settled APTs in the US. This is one reason, by the way, why notwithstanding statutes like New Hampshire's, some people might not want to do this in a state like New Hampshire. They might still want to go over to the Cook Islands or something like that. This guy, even though the trust instruments were good, there was no allegation that there was a backdoor in the trust instrument terms. And even though he demonstrated, look, judge, I've ordered the trustee to disgorge the funds and they won't do it, the judge still concluded, based on really not a lot of evidence, that there was some sort of backdoor de facto arrangement where this guy could somehow, notwithstanding the trust terms, get control of the funds. And he held the guy in civil contempt. And there's really nothing else, there's nothing the guy could have said to get out of this scenario because the trust instruments were on his side. There wasn't a lot of direct evidence holding there was any problem here. basically probably because the trust was based and administered in the U.S., that kind of fact can lead a judge to say, I'm skeptical this is really what it claims to be. So this is one reason why Cook Islands trusts are still in demand, even though New Hampshire and states like New Hampshire still have statutes like this. Now, I won't spend a lot of time on this unless there's questions about it. This is becoming increasingly disfavored, but there's a doctrine of self-created impossibility, which theoretically allows judges to hold you in contempt if you created the impossibility at issue. This comes up in not just APT cases, but all kinds of civil contempt sanctions. This is pretty theoretical and is, like I mentioned, is increasingly disfavored legally. Judges don't really hang their hat on just this. They may mention it as an argument in the alternative. But usually in these cases, there's a nexus in time between the creation of the impossibility and the order to do the thing alleged to be impossible. So if you 60 days away, and that's typically about where the cutoff is when this does come up, 60 days away from the order, on either side of the order, you create the impossibility. A judge may theoretically find self-created impossibility and still hold you in contempt. And so lawyers that do asset protection trusts say it's better to create an APT when your legal seas are calm. You want to, yes, you're worried about potential future creditors, but ideally when there's no specific creditor, prospective creditor on the horizon, someone who might come after you in a civil case, that's the best time to create an APT because there's no nexus to any potential self-created impossibility. But, and I mentioned here, and this is one thing that I showed in the law review article that I co-authored, every single published case finding self-created impossibility, judges realize this doctrine is pretty tenuous. It probably violates the due process clause. So what I found in the paper that I wrote is no judge has ever found just self-created impossibility and held someone in contempt. They also will find that there was a backdoor in the trust instrument terms, or there was a de facto backdoor, or that you failed to meet your burden of proof. All right, next slide. And so we propose in the law review article blockchain asset management, which is doing an asset protection trust on the blockchain. And again, this is an area where there is, as you've just seen, this big, expensive, and risky area of law where the entire thing that is generating the expense and the risk is the question of immutability. So the blockchain is the best way we have to create protocols or systems that are immutable. And the blockchain could theoretically just wipe out this whole area of litigation in this practice area. So you could replace the functions of a Cook Island trustee with smart contracts and oracles. That would make it easier to meet your burden, because remember, it's your burden of showing impossibility. All your attorney has to do is just explain to the court how the blockchain works and how a smart contract works. That's going to go a long way to showing immutability. You don't have to worry about parsing both trust instruments and this universe of facts in the world. A traditional Cook Islands APT, you've got to worry in terms of evidentiary findings about the terms of your trust, but also what's the judge going to infer from testimony? Is he going to find that you're buddies with the trustee and the trustee actually would do what you want him to do for that reason? Is he going to make some unfalsifiable finding of a de facto backdoor? That's going to be pretty much taken off the table if you do this on the blockchain because there are no people. There are no people that could theoretically make a discretionary decision if the protocol says, let's take my Florida 2014 case. If the protocol had said, hold on to my $1.7 million, release $10,000 to me a month indefinitely and do nothing else. Obviously, you might want to build some flexibility in there, but that's a system that some people use in settling APTs. Then there wouldn't have been any question about, all right, I'm going to hear, as a judge, I'm going to hear testimony from different witnesses. I want testimony from the trustee, other people involved in setting up the trust. I want to see if there's a de facto backdoor. There's just no possibility of a de facto backdoor. The question is, what are the protocols of the trust? Skepticism about the situation. If a judge is incredulous, I can't believe that this could possibly be real. You just explain to them what the blockchain is. That's going to be a lot easier than going through all the hoops that people jump through in traditional APT contexts. And the judge is unlikely to honestly conclude there's an unfalsifiable or other imagined de facto backdoor in the smart contract. All right, so last slide, and this will be my last couple of minutes here. So what could New Hampshire do to take advantage of this opening? Well, it could do basically what it's done already in the area of traditional APTs, which is not to create the possibility of a blockchain-based self-settled APT, because the possibility already exists. I would advise someone to do this now. I think just under pre-existing case law, this instrument could work really well depending on your needs. That is, if you have needs that correspond to a traditional APT, I would pretty much categorically tell someone, if you can do this on the blockchain, this is going to be a lot better for you and safer for you legally and less expensive to litigate if you ever need to litigate it. But just like New Hampshire didn't create traditional APTs, they arose just through attorneys kind of identifying legal needs and the logical structure of civil contempt and due process. New Hampshire also passed laws to say, all right, we're going to add some additional clarity around this issue in New Hampshire to attract some of this business to the state, as opposed to some other jurisdiction. And New Hampshire could do this in this area. So just like we've done in our traditional APT RSAs, you could say, we expressly are going to take personal jurisdiction where there is a matter involving a blockchain-based self-settled asset protection trust created or administered in New Hampshire. You want to have some physical hook to encourage people to move some people or things here to contribute to the GDP of the state. And you could say, all right, a smart contract, we're going to expressly spell out in statute, will have the protections we in New Hampshire afford to an irrevocable spendthrift trust if its protocols would be sufficient to create an irrevocable spendthrift trust under our current RSAs. That would be a sentence like that would be a simple way to do this, to just say, all right, if it's a blockchain-based protocol version of what we already allow, we're going to expressly recognize that. That way you wouldn't have to do a lot of convoluted parsing and amending of the pre-existing trust statutes. And I think you would probably want some sentence along these lines. In any legal matter involving a trust, any alleged contemner shall be presumed to have a common law defense of impossibility to the extent that the person is ordered to modify the functionality of a smart contract. This would create some added assurance for people who want to potentially invest in this area in the state by just saying, all right, we not only do you have this defense kind of in the case law, but we in New Hampshire recognize how a blockchain works. We understand that a well-constructed decentralized smart contract is immutable. You would want to build that into the relevant statutory definition of smart contract or just use a good pre-existing statutory definition. And therefore, we recognize that if this is structured the way it says it is immutable. So that's helpful to judges because judges can look at this statutory definition and say, all right, I don't need to walk through all the case law. The legislature has addressed this to some extent. This is legitimate. And it's going to give assurance to someone who's considering setting up a blockchain-based APT in New Hampshire as opposed to somewhere else, that we are the kind of jurisdiction that's capable of handling this kind of litigation. So that's my presentation. We'll do the last slide here. If you would like to read the full article, I have a list of my law review articles available just at my personal webpage, which is ianhuyett.com, and you can also reach me by email at my email. And I'm happy to take any questions, though, while I'm here.
Great. Thank you very much. I just want to point out there is some draft legislation on the commission's website. You can find it in the resources section. I'll link to it in the meeting minutes. So we do have something sketched out, but decided to study it further. So questions?
Yeah, thanks.
Professor?
Thanks for this. This is very informative, and I enjoyed learning about APTs. You're right. I think, although I did smile a bit when you said that the easy part will be you just need to explain to Judge blockchain. So hopefully we all get that joke. I do have a question, though, about trust law, not my area of focus, but my understanding was that New Hampshire trust law and uniform trust law in general kind of requires a trustee for an irrevocable trust. The trustee has to be a person, and the person has to be an entity. Now, an entity doesn't have to be a natural person. It could be a corporation, but fundamentally, a blockchain is not a legally recognized entity. Now, There's concepts around DAO wrappers, and that's an area of interest to me, so maybe I'm pulling us afield here, but it does seem to me that there would be some legislative change needed to RSA 564B to account for a non-person trustee if we were to fully embrace the blockchain method. Could you elaborate on that?
Well, it couldn't hurt. That would be a good idea. One reason I think you don't absolutely need to do that, although I'd certainly support it and it would only help, is that if you just had that last sentence in my penultimate slide, that would probably be sufficient to do most of what you would need to do to make New Hampshire a leading jurisdiction in this space. Because if you think back to how did attorneys just come up with the concept of an APT, attorneys who were litigating around financial instruments and protecting client funds, just kind of looked at the pre-existing doctrines of due process and civil contempt, and they said, oh, wait a minute, I can really protect client funds by using this impossibility defense. And that's why I'm going to create this instrument in the Cook Islands. So strictly speaking, whether or not it is a trust statutorily, or even whether or not it's a trust at common law, you've accomplished your goals by creating the impossibility defense as such. And so you really just need the blockchain to create what in civil contempt and trust litigation is called impossibility, is just the same thing that in the blockchain context we call immutability. It's the exact same thing. So you really just need that concept. But yes, I agree. It's good to build on top of that additional systems that reassure courts that we've thought about this and we've created a kind of coherent model. And to the extent that, yeah, we can further amend our trust code to incorporate this concept, I think that would be helpful.
All right. Any more questions?
I just had one, just a quick technical question. I know we have to move on. You were talking about the blockchain and the Oracle on the second to last slide. Are you thinking in your mind, this is a layer one like Ethereum or something that becomes so credible that there's just no question? Because I can imagine if there's a kind of a private chain, this could really fall apart.
Yeah, for sure. No, you wouldn't be able to do it on a private chain. I think what you would want to do is, you wouldn't want to be able to do it on a private chain that was theoretically amenable to like centralization of control, right? You want to satisfy the court that what you've got is decentralized so that you can show impossibility. So, a potentially easy way to address that is just require decentralization and have a robust definition of decentralization in your statutory definition of what a smart contract is. That way, if it's a chain that's realistically amenable to being centralized by some actor, then it's just not even legally a smart contract. And then you don't even run into those sorts of analytical questions when it comes to interpreting the kinds of provisions I suggested.
If you could just briefly define Oracle and how immutable is an Oracle, I guess that would be another interesting question.
Well, it depends on how you structure the Oracle, but the Oracle, as I understand it, Representative Ammon, is just anything that gives input into the smart contract about the state of the world, so that the smart contract knows when and how to execute certain pre-programmed protocols. And so an obvious example, I worked with, after I co-wrote this law review article, I worked with a programmer to create a blockchain-based APT, and there was an oracular system only to tell the smart contract what date it was, so that you could have a monthly distribution of funds. But you could have theoretically a centralized Oracle giving inputs into a decentralized smart contract, and that would probably not be good. Then you would kind of defeat the whole point. So you need the Oracle itself to be sufficiently decentralized, and there are some pre-existing systems out there you can use to do that and tie into your smart contract.
And then how would this benefit the state of New Hampshire? So charitable trusts are governed by the Attorney General's office. Trust law in general, is that also under the Attorney General's office?
Only if it's charitable.
Only if it's charitable. The trust companies are under banking? Okay. And so how could this be structured in a way that the state has a stream of revenue coming in from these trusts who happen to be parked here under this theoretical statute that we're talking about?
Yeah.
If you could just describe that.
Well, I should say maybe for context, I mean, the Cook Islands is pretty much the best place in the world to do traditional APTs, and they're not fantastically wealthy or anything. I mean, they bring in tens of millions of dollars a year into their small island country by doing this. So, I mean, it's not like we would generate billions of dollars by doing this. But the reason they do bring in money, even though most of the money all is sitting in these APTs and is inaccessible legally to the Cook Islands themselves, is that you've got to have some hook to administration and physical presence in the Cook Islands. So you want to do something like that first sentence I put in my first slide, which is, in order for this to be recognized in New Hampshire statute, this thing has got to be created in New Hampshire and or administered in New Hampshire. And you could potentially require both. To what extent administration is required obviously is going to depend on the terms of the smart contract. But I think you want some physical hook to say, all right, you're going to get these added protections if the business/law firm creating these is here, so people need to send people or stuff to New Hampshire, then we would have some of the kind of revenue that the Cook Islands and jurisdictions like that have. But it is important to note, part of the reason the Cook Islands is able to generate revenue around this is they've also adapted their legal system to accommodating disputes around these sorts of structures. And so the best way to kind of replicate that model in New Hampshire would be to do something like the statutory language I proposed or that we were discussing, but also do, execute the previous commission's recommendation on a blockchain dispute docket, so that we signal that our legal system is specialized around blockchain-related disputes.
All right. Any other questions? Thank you very much.
Thank you.